In 1861, a man named James Lynch told William Knight something about William's wife. He told him that Jane Knight had been almost seduced by another man before her marriage. He told him that a woman of that history should not be introduced to respectable society. William Knight sent his wife out of the house. Jane Knight sued James Lynch for slander. Her case went to the House of Lords, the highest court in England. There, in a room full of judges and barristers and the formal machinery of English law, the verdict came down. Jane Knight lost. The reason was not that Lynch had told the truth. The reason was that being driven from your own home by a false accusation did not count as provable financial loss. One judge in that room called the rule barbarous. Another called it very cruel. The verdict stood. The law had a phrase for what Jane Knight could not provide. It was 2 words: special damage. Before a woman could sue a man for calling her unchaste or adulterous, English common law required her to put a money figure on the ruin of her life. The friends who stopped visiting were not damage. The husband who stopped trusting her was not damage. The door that closed was not damage. Only the figure counted. Only the number. That requirement did not arrive in English law by accident. It arrived through centuries of decisions about what a woman's reputation was worth. And the answer those centuries kept giving was, nothing you could prove without a ledger. What people actually did before that changed. How women fought back against accusations that could end their lives with a single spoken sentence. And why it took until 1891 for Parliament to move is a story that begins not in a Victorian courtroom, but in a medieval church. The first system was called compurgation. You need to understand exactly how it worked, and exactly why it was never enough. Compurgation is sometimes called oath-helping or the wager of law. It was the primary mechanism by which an accused person in the medieval world, man or woman, cleared a false charge. The procedure was straightforward. The accused stood before a church official or a court and swore an oath of innocence. Then around her, she had to produce a set number of neighbors or kin who would swear not that they had witnessed her innocence, but that they believed her oath. These were the oath helpers, the compurgators. They were character witnesses by another name, except that the stakes were moral and legal simultaneously. To swear falsely on behalf of someone who was guilty was a spiritual risk, and in some jurisdictions, a legal one. The number required varied by the seriousness of the charge and the status of the accused. Usually it was 11 or 12, but the requirement could scale to a number that revealed how much the system measured reputation by social standing. In 899, Queen Utah of Germany stood accused of adultery. To clear her name, she had to assemble 82 knights willing to swear to her chastity. She assembled them. She was acquitted. The number is staggering. It is also the entire logic of the system made visible. The more powerful the accusation, the more of your community had to be willing to stake their own standing on yours. Picture where this happened. The accused woman stood in a church hall or a court chamber. The stone floor was cold. The light came through narrow windows. The oath helpers ranged around her, each one speaking in turn. No physical evidence was presented. No documents were examined. What was being tested was the texture of her social world, whether the people who knew her, who traded with her husband, who sat in the same pew on Sundays, were willing to absorb the risk of defending her. The ceremony was not a trial in the modern sense. It was a vote, taken in the form of an oath, about whether a woman's community still recognized her as one of its own. When the community did, the system worked. The records of the ecclesiastical courts at York and London contain cases from the late medieval period where women brought defamation suits and won their purgation. A documented case from 1496 records a woman named Christina Fressel, who brought a suit against someone who had imputed sexual dishonor to her. She succeeded. The defamer was required to perform public penance, to appear before the parish congregation in a posture of contrition, to ask the victim's forgiveness aloud, to promise not to offend again. The accusation was, in theory, publicly retracted. But the system's failure was built into its structure, and it operated most brutally on the women who needed it most. Compurgation was a social system. Your oath helpers came from your community. If the accusation had already spread, if the word had moved through the marketplace and the churchyard and the cluster of neighbors at the well, the very people you needed to defend you had already heard the rumor. They had already decided, before the hearing, whether they believed it. And because swearing falsely on behalf of a guilty person carried moral and sometimes legal consequences, neighbors might simply refuse to appear for a woman whose reputation was already uncertain in their minds. The documented case from the Lincoln Deanery records in 1479 shows the system consuming itself. Isabel, wife of John Austin of Kirkgate, had been in the habit of calling her neighbors whores and strumpets, and a third insult the court records render as fisinagas. When she herself was later cited before the court for being a common defamer, she needed compurgators. Not one of those neighbors was willing to stand for her. She was sentenced to walk barefoot in the church procession on 2 consecutive Sundays, wearing only a kirtle and carrying a penny candle as an offering before the image of St. Edmund. The accusation had poisoned the very resource the defense required. Compurgation appeared in early Germanic law, Welsh law, early French legal custom, and the canonical procedure of the medieval church. These traditions did not share notes. They arrived at the same answer to the same problem independently, across centuries and regions. When there is no physical evidence, the community's collective willingness to stand for you is the closest thing to proof. That convergence tells you something important. It tells you that what pre-modern societies understood about reputation, before any formal legal framework existed, was that reputation lived in other people's mouths. The problem was that a false accusation also lived there. The system trusted social knowledge to correct itself. It had no mechanism for the moment when social knowledge was the weapon being used against you. The legal phrase special damage does not belong to the world of compurgation. That phrase is centuries away, but the underlying logic is identical. Compurgation required that your community still valued you enough to say so under oath. The common law would later require that you prove your loss in money. Both systems put the burden on the woman. Both made the measure of her injury the wrong question. When the church courts formalized their jurisdiction over sexual slander in England, women gained something compurgation had not reliably provided: a defined institutional process. From the medieval period through 1855, sexual defamation cases were handled by the ecclesiastical courts, the same courts that handled marriage, adultery, and sexual misconduct generally. Historian Stephen Wadhams, working from court records and lawyers' correspondence covering the period from 1815 to 1855, found that women constituted 90% of all complainants in sexual slander cases. They flooded these courts. They named their accusers and described the words spoken and asked for their reputations back. The remedy the courts could offer was penance. If a defamer was found guilty, the sentence was a ritualized public confession. The procedure took place in the vestry room of the plaintiff's parish church. A small audience gathered. The defamer stood before the court officer and spoke the required words, asking the pardon of God and of the plaintiff, promising not to offend again. The victim heard the words. Her name, in theory, was restored. Laura Going's research on the London church courts in the early modern period documents how intensely women used this system, especially in the early 17th century, when litigation in cases of sexual slander rose sharply in the south of England. The women who brought these cases were, as Going and Wadhams both find, overwhelmingly of modest social status, the wives and daughters of tradesmen, craftsmen, sailors, and farmers. Not the powerful. The women who had the most to lose from a rumor and the least ability to absorb it through wealth or connection. Stand in that vestry room for a moment. The room is small. The light is gray. The defamer is before you, speaking the required words, not because he believes them, but because the court has compelled him to. The words are recorded. You have your acknowledgement. You walk out into the parish, where some of the people who heard the original accusation were not present in that room, and some who were present in that room will not repeat what they heard there. And the rumor has, in the weeks since it began, already done its work in ways the court has no mechanism to reverse. Because the ecclesiastical courts could compel penance but could not award money, the remedy was entirely symbolic. If a woman's marriage had deteriorated, if her employer had dismissed her, if her friendships had dissolved, the court could not compensate her for any of it. The damage had to be endured. The acknowledgement was real, but the remedy had no reach into the actual life the slander had touched. And then, in 1855, Parliament abolished the jurisdiction of the ecclesiastical courts over sexual slander. The long-running institutional structure through which women had, imperfectly but genuinely, fought back was closed. What remained was the common law. And the common law had a rule. At common law, spoken defamation was only actionable without proof of damage in 4 specific categories. If the words accused the plaintiff of a crime punishable by imprisonment, if they imputed a contagious disease, if they damaged a person in their trade or profession, or if they fell within a small number of other established exceptions. Calling a woman a whore was none of these things. It did not accuse her of a crime. It did not impute disease. And women, who were not formally recognized as independent professional actors in most circumstances, could rarely claim it damaged their trade. What it did, in case after documented case, was destroy marriages, end friendships, close social doors, and in some circumstances drive women physically from their homes. None of that was special damage in the legal sense. The courts acknowledged this repeatedly. In Lynch v. Knight in 1861, Lord Brougham used the word barbarous while upholding the verdict against Jane Knight. Chief Justice Cogburn, examining a similar case 3 years later, described the rule as very cruel. The language of these judges tells you that the law was not invisible to them. They saw what it did. They upheld it anyway. Because reforming it required Parliament to act, and Parliament had not yet acted. In 1788, a woman named Mary Smith was effectively expelled from respectable society in her English community when a neighbor accused her of carrying an illegitimate child. She was ruined, as historian Jessica Lake describes it, and banished from civilized society by a single spoken accusation. She sued for defamation. By the logic of the common law, she should have lost. She could not prove that the accusation had caused her a calculable financial loss. Her banishment from her social world was not special damage. Her isolation was not a figure that could be entered into a court record as a sum. Smith's case did not become a famous legal victory. What it became was a starting point. The reform conversation that her case entered crossed the Atlantic and moved through decades of litigation and legislative debate. North Carolina removed the special damage requirement for women accused of being unchaste in 1808. Kentucky followed in 1811. Missouri in 1835. New York in 1871. The Australian colonies moved through the mid-century years. New South Wales in 1847. South Australia in 1865. Victoria in 1887. England passed the Slander of Women Act in 1891. New Zealand followed in 1898. These were not coordinated reforms. Each jurisdiction moved independently, responding to cases that women had brought in their own communities, cases that produced the same result over and over. A woman with her reputation destroyed, a law that asked her what dollar figure she had lost, and a gap between those two things that could not be bridged. The reform wave was transnational, not because reformers coordinated it, but because the injustice was structurally identical everywhere the common law operated. The 1891 Act was 30 words. It stated that words spoken and published which impute unchastity or adultery to any woman or girl shall not require special damage to render them actionable. 30 words ending centuries of precedent. The accusation itself was now the injury. The law had finally agreed to count what was actually happening. Who drove it to that point was not primarily Parliament. It was the women who kept filing cases in the thousands across decades, losing on the special damage requirement and coming back. Their cases built a record. The record built a political argument. Parliamentary member William Downey Stewart introduced a bill in New Zealand in 1880, noting it was based on New York's 1871 legislation. The debates in London and Wellington and Melbourne all referenced each other. The reform was transnational not in its organization, but in its evidence. The same case, filed by different women in different cities, showing the same gap in the law, the same way. There is something else in this history that the title question does not fully prepare you for. The ecclesiastical courts that women used to defend their reputations were the same courts that could punish them for the conduct the slander described. The system that offered a woman the possibility of vindication was structurally identical to the system that could convict her. You went to the same institution to clear your name that the institution used to manage sexual misconduct. The court that could compel your accuser to apologize was the court that could require you to perform penance if the accusation turned out to be supported by evidence or even by enough testimony to satisfy the judge. This means that going to court was not a safe choice for every woman. It was a gamble. If you brought a case and your compurgators held, if no one came forward with evidence the court found credible, you were vindicated. If you brought a case and the community did not stand for you, if witnesses appeared who knew something or claimed to know something, if your accuser had allies and you did not, the hearing could become the trial you were trying to avoid. The record you were trying to clear could become the record of your conviction. A woman who did not go to court left the accusation unchallenged in her community. A woman who did go to court risked having the accusation confirmed by the only institution with the authority to confirm or deny it. The only path that was genuinely safe required a community that would stand for her, an accuser with no supporting witnesses, and a judge willing to find in her favor. For women without wealth, without powerful connections, without deep roots in their community, that combination was never guaranteed. And this is where the phrase special damage reveals its full meaning. When the common law required a woman to prove special damage, it was not merely describing a procedural hurdle. It was encoding a position that a woman's reputation was not, by itself, a thing the law recognized as worth protecting. Her grief was not damage. Her sleeplessness was not damage. The fact that her husband stopped trusting her was not damage. The fact that she could no longer walk through certain parts of her town without hearing what had been said about her was not damage. Everything the slander actually did to her had to be translated into a money figure before the law would notice it. The law was not designed to be blind to what was happening. It was designed to look at what was happening and ask only, but what did it cost? The Reform Acts that began in North Carolina in 1808 and reached England in 1891 did not just close a procedural gap. They changed what the law was willing to count as real. Return to Jane Knight in 1861. Her husband had sent her from the house. She had brought her case to the highest court in England and lost. under the Slander of Women Act that Parliament passed 30 years later, that case would have ended differently. The accusation itself would have been actionable. The loss of her home would not have needed to be converted into a financial sum. The fact that a man had spoken a lie that destroyed her marriage would have been finally enough. Before any of that existed, women had compurgation, a circle of neighbors swearing to your character in a church hall, a system that worked when your community was intact and failed precisely when the accusation had done its worst. Then they had the ecclesiastical courts, which could compel public retraction but could not compensate, and which disappeared entirely in 1855. What remained was a common law that required them to price their destroyed lives before it would acknowledge those lives had been touched. The reform that changed this took nearly a century of litigation by women who kept filing cases they knew they would likely lose, building a record that Parliament eventually could not ignore. The women in those 19th century courtrooms came from modest backgrounds. They were not famous. Most of their names survive only in court records and lawyers' correspondence. They went to court knowing the law was against them. Some of them won anyway. Most of them did not. All of them made the argument that their reputation was worth defending, and that a society which disagreed with that was a society that had decided a woman's word, her standing, her place in her own community, was not a thing the law needed to protect. If you have a sense of which part of this history surprises you most, the gap in the law or the length of time it took to close it, I would genuinely like to know your answer in the comments. If this kind of history is what you find yourself thinking about after the video ends, it would mean a great deal if you continued watching here.